Hello everybody. Welcome to the Swiss Patent Litigation Fireside Chat. It's already the 32nd edition. Time surely flies. As always, the last Wednesday of a month over lunch. I've shared the agenda over LinkedIn yesterday. It's quite packed. As always, I'm happy to see your comments in the chat on LinkedIn. If you wish to leave a comment, I will try to keep an eye on that and maybe take it up during the session already, or at least afterwards if I miss anything. So I'd suggest we directly dive in. So the first case that I wanted to briefly touch is litigation between Bayer and Helvepharm. That's an infringement case, 2022-006. These are main proceedings, and there have already been summary proceedings. A PI was issued in summary proceedings, and this is now the main proceedings, the subsequent main proceedings. What's it all about? It's about Sorafenib tosylate. Here you can see the attacked embodiment of the defendant, Sorafenib Sentiva. The molecule at stake is a cancer drug. I think it's against kidney cancer, if I'm not mistaken. On the right side, on top, that is Sorafenib, and that's a pretty hydrophobic molecule. In order to improve the uptake of the drug, it's pretty common to form a salt. And on the bottom side, you can see, and the bottom part on the right side, you can see the tosylate. So it's Sorafenib tosylate. That's what the case is all about. Now, there are two aspects. It's a very technical judgment with a lot of technical details in the validity part of the judgment, but there are two things I would like to highlight. The first thing is there was a request by the defendant to enlarge the panel of judges. It's important to know that typically there are 3 judges on a panel in main proceedings and in summary proceedings, and the defendant requested that the panel be enlarged to 5 judges. And one reason for that request was that in the summary proceedings that I mentioned before, the judgment turned out different from the opinion of the judge rapporteur that had been issued in writing as a contribution to the discussion. And that would show that it's a controversial issue, and that was brought forward as a reason to enlarge the panel of judges. The FPC did not do that, and the reasoning is as follows. It's not uncommon that the judgment does not follow the opinion of the judge rapporteur, and I can definitely confirm that we have seen that frequently, that the actual outcome is different from the opinion of the judge rapporteur. And the reason simply is all judges are free, and even the judge rapporteur is free to change his or her mind after having discussed the case with the other judges and after having heard the arguments in the main hearing. So it's just a contribution to the overall discussion and the deliberation of the judges. So it's a preliminary opinion, and that can change anyway. So the request to enlarge the panel of judges was denied. There is still this banner. Hold on a second. There it is, gone. Okay. So the request to enlarge the panel of judges was denied. And now moving on to the substance of the case. As I said, it's about a molecule that is pretty hydrophobic, but it still is an anti-cancer drug, and you need to make it available to the human body. And the 2 parameters that are typically looked at are solubility on the one hand and the dissolution rate on the other hand. And of course, solubility is of sorafenib alone is not promising. You make a salt, and the first question is, has it been obvious to make a tosylate salt? It's not a very common salt form, but it's also not something that has never been seen before, but it's a pretty uncommon one. And then there was a huge discussion about whether you could determine the solubility and in particular the dissolution rate. And that was really what I would call a battle of the experts. There are so many expert opinions cited in the judgment. That was really a battle of experts. And here on the slide, there is maybe the summary of the judgment, a kind of explanation why the outcome in Switzerland was different from most of the other jurisdictions, I would say. In most of the other jurisdictions, the patent was held invalid, and not so in Switzerland. And the reason that the court presumes, or what the reason is, what the court presumes is that the, how should I translate that? The holistic view should not be disregarded. So you can see that on the next slide. There may well be reasons that each and every step that a skilled person had to take in order to arrive at the claimed invention was obvious, and the defendant has even shown that, but that is not sufficient. All these steps in combination have to be obvious, and if you only take one wrong decision or stop at one point because you don't think that it's reasonable to move on, then the whole subject matter is not obvious anymore. So it's not sufficient to show that each and every step alone is obvious, but the whole combination has to be obvious because otherwise you don't arrive at the invention. And that's maybe the takeaway message from that judgment. Don't forget the holistic view. I think the holistic view, Gesamtschau, I think I called that the word of the year in 2022 or 23 on the blog. Now here it appears again. So never disregard the holistic view in proceedings at the Federal Patent Court. That's maybe the bottom line of that case. Now, moving on to the second case, that's a judgment of the Supreme Court that has been issued recently. I need to make a disclosure notice upfront. Our firm is involved in that case on behalf of the plaintiff. So I will really only briefly summarize the facts here and the course of the judgment. That's a case that went up and down and up and down from court to court. It was really a case that was in limbo for years. The first judgment of the Federal Patent Court was O-2020-017 of August 22. And it really doesn't matter what the case is all about. It's about a construction element for building houses. It really doesn't matter, but the bottom line here is the patents were verbally limited in litigation, and it was held in that first judgment that the verbally limited claim was infringed. And also the Federal Patent Court held that there was a prior user right because one piece of prior art was advanced by the defendant that has been used before the filing date. But that prior user right did not relate to the attacked embodiment. There was a difference between a plate or a rod at a certain place. So that was, in very easy words, the outcome of the first instance judgment. That then was appealed, and the Supreme Court said in the first Supreme Court judgment that the Federal Patent Court should have also assessed the novelty of the verbally limited claims that was held to be valid and infringed. It was held valid simply because there was no attack with the relevant piece of prior art against that claim. But the Supreme Court held, well, it's a bit inconsistent, so to say, to on the one hand confirm that there is a prior user right, and on the other hand not to assess novelty of that claim. What may be added to the confusion later, you will see that was a sentence in the judgment of the Supreme Court saying that if the verbally limited claim should not be held valid, then something else would have to be assessed. And now what was meant with not valid? Does it only pertain to novelty, as the first sentence might suggest, or does it encompass the whole assessment of validity, including obviousness, inventive step? So the Federal Patent Court, well, maybe in an attempt to use the leeway that it felt it was given, or to test the waters, assessed it all the way through, including obviousness, and held that the patent was not valid. So infringement was no issue anymore. That again was appealed to the Supreme Court, and the Supreme Court in the most recent judgment held that the second Federal Patent Court judgment disrespected the binding effect of the first Supreme Court judgment. So the Supreme Court held, well, we only referred the case back for the assessment of novelty and nothing else. So the outcome there was, we are pretty much back to the first instance judgment, the first one, which held that the patent as verbally limited was valid after the assessment of novelty, because it was novel, it was new, and the assessment of infringement has already been done. So in a nutshell, the first instance judgment was confirmed, and just the reasons were amended in a way that also novelty was assessed and confirmed for the verbally limited claim. So yeah, bottom line of that case, maybe if you look for a bottom line, when you look at my summary for the first judgment of the Federal Patent Court, that's already commented on the blog. The key issue there was that not all relevant attacks were made for the relevant verbal limitations. So if anything can be learned from that case, then be careful how you draft your attacks for each and every verbal limitation of a claim. So that was the second judgment that I had on my agenda. The next point is something that I stumbled across in a blog entry from Juve Patent. That's about a patent from Katjes. They are known for various sweets. It's a German company, Katjes, but they are also active in the chocolate business. Here's a heading of the publication of Juve. Lindt infringes vegan chocolate patent in Germany. So that's not a Swiss issue, but it's still a Swiss company. Lindt, at least the headquarters are in Switzerland, and they infringe on that patent of Katjes. Now, chocolate is always interesting, of course. So looking at the claim now, that's a pretty short claim, I would say. It's about a chocolate product. The rest is pretty much standard. It's molded from a chocolate mass. It has either a cocoa butter or cocoa mass. It has a sweetener. That's all pretty standard. And it's also containing at least 1% of hydrolyzed oat flour. Yeah, that's a claim. Now, looking at the products of Lind, I started to get nosy, of course, you know me. So I was looking for the Lind products back in the days when that litigation obviously started. And that was the Hello range of products from Lind. And they advertised as a component in that chocolate Hafer drink, loosely translated to English, Hafer oat drink. So yeah, as I learned from the publication of Juve, Lind apparently said that, well, it's not that much of a trouble meanwhile because we changed the recipe. And indeed, when you now look at the current package of the Hello vegan chocolate from Lind, there is a mentioning of a new recipe. You can see that on the left side. And when you look at the constituents on the right side, there is still oatmeal comprised. I have no idea whether that oatmeal is hydrolyzed or not. At least it comprises oatmeal. But apparently Lind feel that is not infringing, at least not anymore. So they changed the recipe. Now, looking a bit more in the Juve publication, and I will share the browser now. That is the website with the Juve publication. And that triggered me to dig a bit deeper because there is a mentioning that there are also opposition proceedings ongoing at the EPO, and that there are quite some other opponents. And one of them is the Swiss retailer Coop, and Coop is represented by MLL, Meyer-Lustenberger, Lachenal, Frohrib. Now that was interesting to me because that firm is mostly known for their litigation practice. Of course, they have a patent attorney in-house, that's Ulrike Ziesler, and she may, of course, represent clients at the EPO. That's all good, but that's not standard for MLL to just do EPO opposition proceedings when there is no litigation around. So that made me think what's going on there with Coop. And when you then look at what Coop has in their product range, you stumble upon Karma chocolate, Chocolaf, that's also mentioning that it's vegan and that there is oat drink included. You see that here. And now enlarging the view a bit, what that chocolate also comprises is oat powder hydrolyzed. When you now recall the claim that required oatmeal hydrolyzed, maybe there is a discussion about whether oat powder is oatmeal. But apart from that, yeah, as I said, the claim is short. That's what this Coop chocolate has as ingredients. I'm not sure what's going on in Switzerland, but I would at least not be surprised if we sometime down the road we might see some publication in Switzerland about proceedings going on at the Federal Patent Court too. So that was the third real patent stuff that I wanted to briefly discuss, and then I had AOB on the agenda that I shared on LinkedIn. Now, AOB. There's one AOB that, let me share the other screen again, that concerns litigation between Werner and Merz. That's a German company. They are pretty well known, at least in Germany, for their cleaning agents of the brand Frog. It's a pretty well-known brand, and they were litigating against Good Soaps, but the patentee there, the patent holder was Compat Consulting, but the licensee of that patent in Switzerland was Good Soaps. So they were litigating about ownership of a certain patent application, a European patent application. And I reported about that case on the blog already, and that was decided in the favor of Compat Consulting or Good Soaps, respectively. So the assignment action of Werner and Merz was dismissed. It was not appealed, so that judgment was final. But apparently the parties are not yet done with each other, because when you then look at the EPO opposition proceedings, meanwhile, the former plaintiff, Werner Merz, lodged an opposition against the grant of the European patent of Compat Consulting, and they now, Compat Consulting, requested that the opposition proceedings be treated accelerated because they lodged an infringement case against Werner and Merz in Germany at the regional court in Munich. Apparently, as I said, the parties are not yet done with each other. They are really exchanging hefty briefs at the EPO. I think the opposition brief was around about 200 pages. It's enormous, really. The reply was around about the same volume, and with a later submission, the patentee submitted certain experiments that should prove the patentability, and with that further submission, they requested that the opposition proceedings be accelerated. There is nothing yet on the file about the subject matter of that litigation. The statement of claim is not in the file. Nothing has been submitted, just this small section in the last submission of the patentee. But I'm pretty sure we will see more of that case, that infringement case, soon. The other case that the other topics that I mentioned as an agenda item upfront on LinkedIn was multi-day hearings at the Federal Patent Court. I think that's really for the first time that the Federal Patent Court announced a main hearing that is not expected to be finished on one day, but which is explicitly scheduled for 2 days. That's again an assignment action 2022-011. The first part of that main hearing is scheduled for the 4th of June, so pretty soon. And it says here on the bottom of that public announcement that at that first part of the hearing, only the parties and witnesses will be heard, and the final pleadings will be held at a later point of time. And the later point of time is about a week later, on the 10th of June. So there's around about a week in between these two parts, and it's explicitly held here at the bottom. On that date, the main hearing will be continued. So yeah, I think that's well, absolutely reasonable. These hearings of witnesses and parties, that can always take longer than expected, and then maybe the representatives need to deliberate and then discuss with their clients how to react on what has been submitted by a witness or a party. So it makes sense to somehow separate these two things. And well, to be honest, in my mind, the such proceedings are lengthy anyway, and sometimes it's really hard to put each and every argument in a 1 hour pleading that you want to make. And if it takes longer, then it takes longer. So a 2 days main hearing is not a bad thing. I understand that there is an interest to conclude a matter as quickly as possible. But hey, if it takes 2 days, it takes 2 days. So here we are, the first main hearings that are summoned for 2 days. And that's not an exception, obviously, because there is yet another announcement for a main hearing. That's again an assignment action and a counterclaim. You can see the 2 case numbers here. That is also the first part of the hearing on the 12th of June. And it said that on that date, only parties and witnesses will be heard. And here the final pleadings will also be held at a later point of time, but here we don't know yet when that will be. So in both cases that I had just on the screen, there have already been summary proceedings, and both are already commented on the blog. So if you wish to put everything in perspective concerning these 2 cases, feel free to look that up on the blog. But I think it will only be getting really interesting when we learn more about these cases during the main hearing. I will try to attend as always and keep you posted. So the next one is, well, it's about proceedings at the Swiss Patent Office. And yeah, as with any office, one sometimes runs into unexpected troubles, difficulties, surprises. So we had not just one, but at least 2 cases recently, just the last days, about early entry into the national phase of a PCT application. So we filed the request for national phase entry, well, I would say well before the lapse of the 30 months time limit. Not ages before the 30 months time limit. So here we filed it on the 7th of May. And you can see that it's partly blackened, but it's in the first half of June when this time limit actually lapses. So it's, let's say 1 to 1.5 months before the time limit actually runs out. We got a reply from the IPI saying, yeah, thanks for your request. We confirmed we got it. The deadline is, well, in the first half of June. And they cite Article 23 of the PCT saying that a designated office must not examine or process such national phases before the time limit of 30 months has actually lapsed. And the second paragraph of that article says, well, if the applicant explicitly requests early processing, then of course the designated office can do that. And the IPI asked us whether we wish early treatment in accordance with paragraph 2 or not. And that is all fine, no issue with that. But then there was an addition to that email saying that if you don't wish early treatment, so that we pick up the file already now, then we ask you to file the request again, roughly 2 weeks before the 30 months time limit lapses. That's where we wondered for the first time, why should we file it anew? We already filed it. But the last sentence then really struck me. The IPI asked for a reply within a few days, and if we would not reply, they would just disregard our requests as filed. They would just get rid of our documents as filed. Unterlagen vernichten. That's not what I expect from the IPI, obviously, that they just put our request into the garbage bin. What happened then was, of course, we replied and say, well, no, we don't wish an early treatment. We filed a request in due time, and there is no reason for us to file it anew roughly 2 weeks before the actual time limit lapses. We filed it already, and we are not happy with putting our request to the garbage. And we got a reply saying, okay, we acknowledge you don't wish early treatment. So we now tell you that we can't treat or monitor your request, which is why we send back to you your documents as filed. So we got everything back by email. Okay, that made us wonder. And if you wish early treatment, you can file a new request, and otherwise we expect a new request shortly before the 30 months time limit lapses. Thank you for your consideration. Kind regards. That's what the IPI said, and where we now stand. That's really well, something I would call pretty unusual. I had similar. Well, now let me put that differently. The IPI is not the only office that we are frequently dealing with and that handles national phases of PCT applications. The EPO, for instance, does the very same. I recall that when some 10 years ago we filed early requests at the EPO and did not explicitly request early processing of that national phase entry, the EPO simply took it on their file and did not act on it. And we then at one point asked, well, where's my next office action? Please act on that file. And we have been informed then that we need to explicitly request early treatment. That's all good. And we were obviously not the only ones that were not perfectly expecting that the EPO would also expect a formal request of early treatment. And then I think it was in 2013 or so that the EPO, in fact, made a publication in the official journal clarifying that they would not treat the request for national phase entry as a request for early processing too. They required a separate request for that. And that was clarified at the EPO some 10 years ago. And meanwhile, they even have can show you that they even have a tick box on there. Hold on a second, I'll show you that here. There you go. There even is a checkbox in the filing form of the EPO where you can request early processing and all is good. And if you don't check that box, they pick up the file when the 31 month time limit that applies at the EPO has lapsed. As easy as that. And there is also the explanatory notes of the EPO that, well, says exactly that. If you want to have the file processed before expiry of the 30 months time limit, then you need to check the box. And it goes all the way through the explanations what consequences that has if you request early processing, because then you have entered the national phase. You cannot make up your mind later on that you don't wish to have it that way. Once you did that, you have it. But apparently at the IPI, they have a different approach to that. I tried to understand why they feel you have to file the request only roughly 2 weeks before the 30 months time limit. I really have no idea where that roughly 2 weeks before comes from. If you really would take the position that Article 23 of the PCT that prohibits treatment of the file before the time limit has lapsed, if you would take that literally, you could only file the request for national phase entry on a single day, namely when the 30 months time limit lapses. There is no time frame of 2 weeks before when you are allowed to do that, and 3 weeks before it's not okay if you do that. That's not a reasonable reading of that article. What is a reasonable reading of that article is what the EPO does with it. If you file it before the 31 or 30 months time limit and don't request early processing, the request is on file, obviously, because you filed it. They just don't act on that, but they have the request on file and they act on that when the time limit has lapsed. And if you request early processing, they do that. But be aware, you might get an email from the IPI if you file it more than 2 weeks before the time limit lapses, and there is a certain risk that they just put the request into the garbage, which is something I don't like and which I think is wrong. But maybe, maybe I am wrong. We shall see. But it's just a mentioning that be aware that this might cause troubles if you do it more than 2 weeks before the time limit lapses. By the way, checking that in the IPI guidelines, the only somewhat helpful bit that I could find is in the guidelines, the formal guidelines. But that is also only saying you have to do you have to get your stuff done until the 30 months are lapsed. There is no mentioning of 2 weeks before and not 1 month before. And that is perfectly right in the guidelines, but the practice obviously is a little different. So, which brings me to the final point that is not patent related at all. It's something that I had posted on LinkedIn a few days ago. It's remotely patent related, simply because it refers to the Swiss coat of arms, and there is a way to legally use the coat of arms in business, namely if you have a Swiss patent on your product or whatever you are selling. If there is a protection by a Swiss patent, you may legitimately use the Swiss coat of arms. That's pretty cool. That's all part of the Swiss Swissness legislation that was enacted in 2017, and there was a 2 years time frame during which companies or entities that have used the coat of arms for at least 30 years and that have an obvious desire to further do that, a legitimate interest to further do that, to file a request. And some companies did that. That was Victorinox, the famous knives, military knives, and I think the Touring Club Switzerland, and there was another one, the Swiss Alpine Club. They filed requests, those requests were granted, and I think those are the only 3 ones. And apart from that, the Swiss coat of arms is reserved for just the state. It's just the Gemeinwesen, the society, the Eidgenossenschaft may use the coat of arms, but not companies, not sports associations. They are not free to use a coat of arms. But when you look at that image here, that was from the NZZ, apparently the Swiss Ice Hockey Federation used the coat of arms. I always wondered why that should be okay. And obviously it was not found to be okay, because I took from the media, from NZZ, that the IPI issued an order to Swiss Ice Hockey Federation to the effect that they should not anymore use the coat of arms. And the Swiss Ice Hockey Federation did 2 things. They appealed against that order, so meaning that the administrative court now has to rule on that. Meanwhile, they played a pretty successful World Championships still with the coat of arms, but in parallel they also found politicians who lodged motions in Swiss Parliament to change the law in order to also allow national teams, Swiss national teams, to use the coat of arms. Yeah, if you don't like the law, get it changed, fair enough. But my bottom line there was, it's in German. It's really literally taken from my LinkedIn post on that. If that is okay, then for a national team to use a coat of arms, then I would just found the Association of Swiss and European Patent Attorneys that also own Irish soft-coated Wheaton Terriers. I'm pretty alone in that association, I'm pretty sure. And I will definitely form a national team for that kind of agility sports with my dogs. No worry about that. I will do that. So here you can see the national team. That's me with one of my dogs. So if you allow that for a national team, I will be happy to use the Swiss coat of arms too. So that was it for today. Yeah, I would be very happy if you join me next month again. As always, the last Wednesday of the month over lunch. Thank you for joining today. I will have a look at the comments on LinkedIn if there are any. I will definitely answer them as soon as possible. And to be honest, I did not look at the comments while I was now talking, but I will do that later on. So thanks for joining again, and enjoy your lunch if you did not have one yet. And bye-bye. See you next month. Bye.